I am Medha. I am here from the Foundation for Democratic Reforms. Today we have Dr. JP with us. As of recent, the Uttarakhand has passed the UCC and we are here to talk about it. But let us start from the beginning. Sir, if we are to assume, if you are to compare Uttarakhand's UCC, the general concept of UCC with that of Lewis Carroll's fabled snark, no one knows what it is supposed to do, no one knows what it looks like. How do you envisage a uniform civil code?
Mesa, this whole debate on uniform civil code has been hijacked and polarized because of ferocious religiosity and politics. Our constitution clearly recognizes the right to practice your own faith. And the customs and other practices that you indulge in as a part of that faith, it's entirely your business, which God you worship, with whom you live, whom you love, all those things. But this right to worship, right to your own faith, cannot extend to certain issues. There are certain fundamental constitutional rights to everybody. Our constitution does not recognize gender discrimination. It rejects it. Right from day one, take universal franchise. India is the first country in the world to grant the right to vote to every citizen. Does not acknowledge caste, region, religion, language, or gender. Even Britain, which is in many ways considered as the mother of parliaments, which started the democratic journey in way back in 1215 with Magna Carta, it took some 8 centuries, at least 7 centuries plus, for women to get the right to vote. Only in 1928 did the women got the right to vote. 713 years later. United States, which actually started in European tradition and then built upon that in 1619, democracy in some form started in the state of Virginia. The women got the right to vote only in 1920 after a prolonged struggle. Whereas Indian constitution makers made sure that women got the right to vote along with men of all faiths from day one. So the constitution, in certain senses, prescribed certain values, certain practices. The gender rights, child rights, and the fundamental notion of human rights. In that expression was not used in the Constitution per se. That whole debate of Universal Declaration of Human Rights certainly permeated the Constitutional Assembly debates. So, on the one hand, you have the right to religious faith and freedom of worship. On the other hand, you have certain fundamental rights which nobody can be denied, irrespective of gender. Now, let me make a slightly more controversial point. In almost all religious faiths, there has been an overt or covert discrimination of women. Women were regarded as a subjugated subspecies, and man was given supremacy. It is not to insult any religion. That's how perhaps human society has evolved over time. The domination of the male has been one of the obvious features of human evolution for centuries, for millennia. Now, in today's world, in 20th, 21st century, you don't accept that women are inferior to men. Therefore, if the rights of women are subjugated in the name of religion or custom or tradition, then obviously the constitution or the law cannot sanctify it. Then there are certain practices. In good faith, perhaps those in the faith practice them. But they are dangerous superstitions inimical to health of certain people. Like, in some societies, there is genital mutilation of female children. In some other societies, there are some other heinous practices. Now, if you allow them to continue without any constitutional legal protection to these unfortunate victims, then that's not a modern society. So, I think, to my mind, the balance is very clear. The state has no business to intervene in matters of religious faith and worship unless, that is the proviso, unless the practice of certain customs and traditions within a faith are inimical to individual freedom as envisaged under the broad constitutional scheme of things. Once you put it that way, you take it out to this uniform, non-uniform, I think a lot of confusion disappears. In Uttarakhand, you mentioned, I'm not a scholar, I have not studied carefully, but even at a glance, what you notice is there is a provision needlessly incorporated in the Uniform Civil Code that is enacted, registering live-in relationships. If voluntarily two partners register their live-in relationship in order to get certain rights of inheritance, of custody of children, of some other things, that's perfectly okay. But to force them to register and to give the discretion to the registering authority will certainly be construed as intrusive. I don't think it is ever envisaged to be a part of the civil code to enforce constitutional values. Therefore, we must not be confused between the package and the substance, and between this overarching framework of uniform civil code, which arouses so much of debate with animosity, and the broader constitutional values that need to be protected. To sum up, in my judgment, religious freedom is sacrosanct. Freedom of worship is sacrosanct, but only if it does not impinge on the freedom of any one of the practitioners of it because of gender, age, or something else, subject to that. And therefore, any kind of a civil code or legislation should address that part and definitely address that part and no more.
So this brings to such an insight. This brings to our next question. With the upcoming 2024 Lok Sabha elections, and also it has been observed in states like Assam and Gujarat that they are also trying to bring in a uniform civil code. Do you think this is an election strategy of the ruling party currently?
Yes or no? Yes, in the sense that obviously anything that a political party or government does is political, in the best sense of the term. No, because for the current governing party at the national level, the Bharatiya Janata Party, or its predecessor, Bharatiya Jan Sangh, it has been an article of faith from day one. They never concealed their views. From the beginning, they have been always articulating the need for uniform civil code. And the Constitution, the directive principles did state that there must be uniform civil code. To that extent, I think it's more than an election gimmick. And to the extent that they want to carry the goodwill of the voters, saying that we have fulfilled this promise which is necessary in our judgment, it has certainly an electoral component to it. But I think it must go beyond the elections. This has been a long-standing issue in the country. And therefore, if we take it out of politics and examine it carefully, clinically, and without prejudice or without any fervor, that will be helpful.
So the next question which I would like to ask you is that, is it feasible that every state devise its own uniform civil code? Wouldn't it be better if the central made an overarching civil code which all the states and therefore the citizens would have to adhere to, rather than an individualized state-specific civil code?
Metha, my own bias is in favor of decentralization. Therefore, unless there is a need to have a union legislation and have a nationwide framework, if each state, after all, each state legislature has the power to make laws, I would say this is in consonance with the fundamental rights. Ultimately, to my limited understanding, any law made by the state legislature or the parliament is according to Article 13 of the Constitution. Legislature can make laws in furtherance of the fundamental rights. And therefore, both the legislatures have the legislative jurisdiction under the Constitution. If states make the laws, even if a mistake is committed, you can easily redress it. For instance, in my judgment, a compulsory registration by a registering authority and the discretion on the part of the registering authority regarding live-in relationships is not really necessary. Now, supposing a state made such a law, A, it can be adjudicated in a court of law. B, we can actually examine the views of the public across the country and then take corrective action. And other states, if they're legislating, they can take that into account. If you make a union legislation, the choices are narrowed. So I think it's not a bad idea to make the states enact the laws and see how it works out. And if there are any kinks in that, to smoothen them. There's no need to necessarily have one national legislation. Because again, unity versus uniformity, unity versus uniformity. There is a challenge. Because in India, any diverse society, it's a fundamental question. Does national unity demand uniformity, As a principle, no, unity is not uniformity. Then why uniform civil code? The word is not about uniformity. I think that's an unfortunate expression. It is about constitutional values versus religious practices. If there is a clash, which should prevail? I think these are the two guiding principles as far as I'm concerned. Therefore, each state legislating is not a bad idea. I would endorse that.
Thank you so much for your insight, sir.